Good morning, viewers. I am rlchohan, retired judge. Today I am going to throw some light over changes made by the Parliament in Bharatiya Sakshya Adhinigram. Yes, there is one very important concept that how an accused can be made to be approver, to be Sarkari Gawah for the purpose of acquitting him. In case there are more than one accused who have committed some offense and one accused makes a statement admitting his guilt, now that statement can be read against other accused also. But if he has been declared as approver, then we say that he is now accomplice, he can give evidence and he will also be cross-examined by other co-accused. In order to make this concept clear, I will make reference to earlier position by taking one case. A murder was committed by XYZ. Now, murder was committed of A. A was sitting at his home. Y and Z went there. They were having two revolvers. They fired at A and they killed A then and there. Now, in this case, X was arrested and Y and Z were not arrested. Now, X made a confessional statement before the police that he want to confess his guilt. The police took him to the judicial magistrate. Now, Chief Judicial Magistrate recorded his confessional statement. And in his confessional statement, X narrated the entire story. He said that he went to a gun house and he has brought two revolvers from a gun house and he has handed over these revolvers to Y and Z. And Y and Z went to the house of A and they killed A by firing at A. Now this X further narrated that he took these two revolvers from a gun house and thereafter he has handed over these two revolvers to Y and Z. He further narrated that as per their compromise, X did not participate. Now it means his fault was lesser one. And he made a request that he want to become approver. In fact, in this case, it is a blind murder and there is nobody who has witnessed any that murder. Now, in that case, when there is no evidence, the court can tender pardon to the accused for becoming approver for the purpose of disclosing each and every aspect of the case to the trial court. Now, here the CJM, he has made an agreement with that X that in case he narrates the true disclosure before the trial court, then he will be acquitted. In case he does not disclose the true picture, true disclosure before the trial court, then he will be tried for committing murder. Now, in this case, he has been declared as approver and Y and Z were arrested. Now, there is no other evidence, only the evidence of approver is there. Now, question arises whether on the basis of that statement of co-accused we can convict these Y and Z. Let me make reference. Now section 306, 307 and 308 of cr.pc, they were dealing with such a process as to how a co-accused can be made to be the approver. Corresponding section of Bharatiya Nagrik Suraksha Sanhita are 343, 344 and 345. Yes, now this Indian Evidence Act says about that statement, that what is the evidentiary value of such a statement when it is a solitary statement. Now section 114 clause B says that if some accomplice approver has given some statement, he is unworthy of credit unless his statement is corroborated from independent source. Now in this case there is no other independent source. Now this section 114, it is containing a rule of prudence. Rule of prudence that whenever some co-accused is coming to give evidence against his participants, other co-accused, then that is not reliable, because he may induct many things only for the purpose of getting himself acquitted. Therefore, this rule of prudence is mentioned in section 114 clause B. Now let us see here, the same provisions are there in Bharatiya Sakshya Adhinidham in section 119 subsection 1, exactly corresponding. Now I have brought you people to that context where I want to tell you that what is the amendment, what is the change which has been made by the Parliament. Now section 133 of Evidence Act says that in such a scenario which I have narrated, it is legal if the Court of Session convicts Y and Z on the basis of uncorroborated statement of X. It means this rule of law is contained under section 133, which declares that if the court convicts that those accused Y and Z on the basis of statement of the approver, then certainly we will say it is legal. It is not illegal, although the statement has not been corroborated from independent source. Now there were a large number of authorities that this section 114, it is containing rule of prudence, but 133, it is containing rule of law, and Honorable Supreme Court in various authorities have held that we should follow this rule of prudence. Although it is legal if some accused are convicted on the basis of uncorroborated statements of that approval. Now it happened in the past that many courts, they convicted the accused on the basis of the confessional statement or on the basis of a statement of a co-accused who has been declared as proven. There were many cases. Then Honorable Supreme Court has laid down that we should prefer to a rule of prudence than this rule of law. Yes, now I am coming to that which change has been made. The Parliament has made change in section 138 of Bharatiya Sakshya Adhinidham, which is corresponding to section 133, and they lays down that conviction can only be made by the court if that statement of the approver, accomplice, or co-accused is corroborated by some evidence. This is very important. It means earlier the word uncorroborated was there in section 133. 133 says that it was illegal. 133 says that it is legal if some accused is convicted on the basis of statement of approval, although that statement is uncorroborated. But now the Parliament has made it clear that we will not convict, the courts will not convict co-accused on the basis of uncorroborated statement of approval. In other words, the conclusion is that if some approver has given some statement on oath and he has been cross-examined, and there is one only solitary statement of that approver, then we cannot convict the court of session or judicial magistrate or chief judicial magistrate. They cannot convict the accused on the basis of uncorroborated statement of approval. Alright viewers, this was the change, very important change. In other words, we can say the Parliament has based the change on various authorities, because when Supreme Court has held that we should follow a rule of prudence contained in section 114, this clause B, then certainly we should not follow a rule of law. Now the Parliament has changed the rule of law for the purpose of making it a rule of prudence contained in section 114 clause B, here also in 119 subsection 1 clause B of Bharatiya Sakshya Adhiniyam. Alright viewers, this was very important change the Parliament has made in this section 138 of Bharatiya Sakshya Adhiniyam. Alright viewers, I will appear again to throw some light over other changes. All the best. Thank you.